Thank you very much. Good afternoon. President of the Caribbean Court of Justice, Chancellor of the Judiciary, Chief Justice, Justice of Appeal, both of Guyana and Trinidad and Tobago, judges of the High Court of both Guyana and Trinidad and Tobago, the Director of Public Prosecutions, the Ombudsman, the Solicitor General, Chief Parliamentary Counsel, retired President of the Caribbean Court of Justice, retired Chancellor of the Judiciary, retired judges of the Supreme Court, members of the Inner Bar, members of the Outer Bar, commissioners of title, magistrates, president and members of the Guyana Bar Association, Carol Ann Bernard, daughter of the late Justice Desiree Bernard and other relatives. I stand before you to render my tribute to the Honorable Madam Justice Desiree Patricia Bernard of the Order of Roraima and the Cacique Crown of Honor, who departed this mortal existence on the 28th of March, 2024. She was 85 years old. Her illustrious legal career spanned more than 5 decades. Justice Bernard has certainly etched her name in the annals of legal history of Guyana, the Caribbean, and indeed the Commonwealth. Her contribution and accomplishments have inspired generations of women, certainly in Guyana and the Caribbean. I'll be bold to assert that perhaps more than any other, Justice Bernard is largely responsible today for the high number of females in the legal profession in Guyana and the Caribbean, and similarly for the high numbers of women holding judicial positions in both the upper and lower judiciary. I know for a fact that Justice Bernard was the mentor of and has inspired Madam Chancellor, your good self, the Honorable Chief Justice, and I know Chief Justice of Belize, Louise Esther Blenman, who may be joining us on Zoom. And that's just 3 of the bat. Justice Bernard was born in Georgetown on the 2nd of March, 1939, and from an early age began to exhibit scholarship and academic excellence. After writing common entrance at the St. Ambrose Primary School, she was awarded a place at Bishop's High School, the premier girls' school in the colony at the time. She became part of that famous group taught by Sir Fred Wills, who read law at the University of Guyana from Georgetown through a correspondence program. In 1963, having eventually traveled to London, she graduated with a Bachelor of Laws degree with honors. In 1964, she qualified as a solicitor and returned to British Guyana, where she commenced her practice of law with the firm of Cameron and Shepherd. In 1970, she was appointed a magistrate. In 1976, she became a commissioner of oaths, and in 1977, she was admitted to the English role of solicitors. Justice Desiree Bernard is one who can best be described as a trailblazer, as she has been on a regular basis, accomplishing many firsts in her long, stellar legal career. In 1976, she became the first woman to be elected as president of the Organization of Commonwealth Caribbean Bar Association. In 1980, she was the first woman to be appointed a High Court judge in Guyana and the Caribbean. In 1982, she became the first woman to serve on the Judicial Service Commission. In 1992, she was the first woman to be appointed a Justice of Appeal in Guyana and the Caribbean. The same year, she became the first female chancellor of the Anglican Diocese of Guyana and the Caribbean. In 1996, Justice Barnard was the first woman appointed as Chief Justice of Guyana and in the Commonwealth Caribbean. In 2001, she became the first woman to be appointed as Chancellor and head of the Judiciary of Guyana and in the Commonwealth Caribbean. Then on March 6, 2005, Justice Barnard took the oath of office as a judge of the Caribbean Court of Justice. During her tenure from 2005 to 2014, she remained the only female judge of the CCJ. In 2011, she was also appointed a judge of the Inter-American Development Bank Administrative Tribunal. After retiring from the CCJ, Justice Barnard was appointed to the Bermuda's Court of Appeal in 2014. Justice Barnard was also a founder member and the first president of the Guyana Association of Women Lawyers, which was established in 1987. She was also the first chairperson of the Georgetown Legal Aid Clinic, an organization that she helped to establish and remain a member until her death. Unexpectedly, Justice Barnard made a significant contribution to the jurisprudence of Guyana and the Caribbean, as evidenced by her many judgments being published in the Law Reports of Guyana, the West Indian Law Reports, and the Commonwealth Law Reports. Justice Barnard's judgments were scholarly, yet simple, well-researched, and carefully reasoned. Her analysis of complex issues of law were clear, clinical, and cogent, and very simple to assimilate by students, lawyers, and judges alike. I got the distinct impression that Her Honor was never afraid to put pen to paper. Most importantly, most of her judgments not only withstood appellate scrutiny, but have withstood the test of time. Today, they remain locus classicus decisions on the areas of law upon which they pronounced. Justice Barnard was adept in almost every area of the law. Her many scholarly judgments spanned various areas of civil, criminal, public, and law. I will bottle minority shareholders' interests, derivative actions, and various aspects of the fiduciary duty owed by a director to a company. In an application by Aubrey Norton for writs of certiorari and prohibition, reported at 1996-1997 Guyana Law Report, page 373, Justice Barnard demonstrated her mettle and fearlessness as Chief Justice of Guyana. This case was filed in the aftermath of the 1997 general and regional elections. Violence and mass protests erupted in the streets. The High Court was surrounded by protesters as the case was being heard. The case was a challenge by the opposition against the swearing-in as Executive President of Guyana of Janet Jagan, the People's Progressive Party's presidential candidate. The chairman of the Guyana Elections Commission had declared Janet Jagan President of the Cooperative Republic of Guyana. Orders were granted to prohibit her from assuming the office of president, preventing the Chancellor of the Judiciary from swearing her in. The allegations were that there were discrepancies and errors in certain aspects of the results, but the Guyana Election Commission had made a decision that the People's Progressive Party had obtained by that time an unassailable lead, which could not have been affected by the votes left to be counted. That was the factual matrix out of which the challenge was born. In a historic ruling, Justice Barnard ruled that the court's jurisdiction was ousted by Article 177 of the Constitution from hearing and determining any question as to the validity of an election of a president, and that an instrument executed under the hand of the chairman of the Guyana Elections Commission was conclusive evidence that the person so named was elected, and no question as to the validity of that election as the president shall be inquired into in any court. In arriving at this destination, Justice Bernard carefully examined a series of cases from Guyana, the United Kingdom, the Caribbean, and other Commonwealth territories, and the views of various text writers on ouster clauses, including Professor Albert Fiaggio in his book Commonwealth Caribbean Public Law, the Smith and Judicial Review of Administrative Action, and Professor Wade on administrative perilous circumstances. That decision was accepted and never appealed. In Ray Hanneman, 1999 65 West Indian Report, Justice Bernard addressed the issue of the importance of public authority to give reasons for their decisions. Today, many statutes, our Judicial Review Act, for example, mandates the giving of reasons by public authorities. In 1999, the position was different, but Justice Bernard was speaking about the desirability to provide reasons when public officers make decisions. Her Honor posited thus, public officials, I quote, charged with the responsibility of making decisions, particularly involving the exercise of a discretion, must do so with fairness and give reasons for the exercise of the discretion so that it can be ascertained whether the discretion was exercised reasonably and according to Lord Green, Master of the Rolls in Wensbury, within the four corners of the principles he enumerated thereof. The exercise of discretion is rooted and grounded in the need and duty to act fairly. This does not mean that the court must decide whether the decision maker is fair. This is solely the function of the person exercising the discretion. What the courts are concerned with is the decision-making process and the manner in which the discretion was exercised and whether it was exercised fairly. In Abdul Salim Yassin and Noel Thomas against the Attorney General, Justice Bernard dealt with how to approach a stay of execution until the hearing and determination of constitutional proceedings in death penalty cases. Citing with approval Lord Brown Wilkinson in Thomas Reckley against Minister of Public Safety, will clutch at any glimmer of hope while there is still life. Unquote. In Marin against the Attorney General, CCJ decision, Appeal CV5 of 2010, Justice Bernard considered a new area of law. It's a case arising out of Belize. The Attorney General sought to recover damages for loss suffered due to alleged abuse of power by the appellants who were former ministers of government, and which it is claimed constitute misfeasance in public office. The loss involved the sale of national lands at an undervalue from which the appellants allegedly obtained financial benefits. On the issue of whether the state could sue a public officer for misfeasance in public office at common law or for the tort of misfeasance, in making the distinction, Her Honor delved into a comprehensive history of both and commented as follows, and I'll be very brief. There has emerged no case in any Commonwealth jurisdiction where governments or states have sought to utilize the tort against public officials abusing powers conferred on them for their own financial gain. We find ourselves in virgin territory in deciding the discrete point which has arisen in this appeal. The objective is to make a public officer personally liable for misuse and abuse of power intended to be used for the public good, but which was used for his own benefit. Admittedly, the criminal offense of misfeasance in public office has always been available to the state and may have been the preferred option for punishing corrupt officials, hence the total absence of any precedents where the tort was used. Of course, if the objective is to recover economic loss due to the public officer's abuse of his power, the tort of misfeasance would be the appropriate remedy. Then, of course, we have the case of Ramdas and Jairam. Here, the CCJ inviting a full bench. I think it's perhaps possibly the first time that the full bench of the CCJ came out to hear an appeal concerning whether equitable interest exists in land law in Guyana. And the CCJ, in a judgment, unanimous judgment rendered by Justice Bernard after going through over 100 years of authorities that were conflicting. One line of authorities established that the courts recognized equitable interest in land, and another line of authorities suggests that the court would not recognize equitable interest. And then you had a third line of authorities where the courts used equitable doctrines and concepts such as constructive trust and resulting trust to confer an interest in a transport property. Hakan Rahiman is one of those cases where they looked at the contribution of the wife and for one moment may have forgotten that equitable interest doesn't ground an interest in land because the wife ending up getting half of the property. But there were three lines of cases that the court had to analyze, and Justice Bernard was shouldered with the responsibility of rendering the unanimous decision of the court, and she did so with distinction. Shanique Myrie is another case out of Barbados, well, out of Jamaica, where the court, sitting in its original jurisdiction, had to consider the revised Treaty of Chaguaramas. Again, Justice Bernard delivered one of the many judgments delivered by the court. In the case of Romeo da Costa Hall against the Queen, 2011, CCJ 6, Justice Bernard considered the important issue of sentencing guidelines and how to approach sentencing and how to weigh the different factors before a proper sentence can be imposed. Apart from her notable judgments, Justice Bernard was a champion of women and children's rights. This passion led her to establish organizations focused on improving the status of women in Guyana and the Caribbean. Justice Bernard's advocacy in seeking equal rights for women and reform in children's law also saw her being appointed to serve on national, regional, and international bodies. In 1972, Justice Bernard founded the Conference on the Affairs and Status of Women in Guyana. She also served as the founding secretary of the Caribbean Women's Association from 1970 to 1974 and was a member and chair of the Caribbean Steering Committee for Women's Affairs, later established as the Women and Development Unit of UWI. In 1981, the government of Guyana appointed Justice Bernard as the chairperson of a committee established to examine the laws of Guyana and make recommendations for the implementation of the provisions of Article 29 and 30 of the Constitution of Guyana, which provides for equality of men and women. The committee was also charged with making recommendations to reform the laws on children. Through Justice Bernard's stewardship, this committee produced key pieces of legislation. For instance, the Children Born Out of Wedlock Removal of Discrimination Act 1983. This led to amendment of the Evidence Act, the Civil Law Act, the Infancy Act, Legitimacy Act, and the Maintenance Act to remove the distinction in the various provisions between children born in and out of wedlock. Consequently, the act was repealed. The act repealed the Bastardy Act. Further, because of the recommendations of that committee, three important legislation were enacted in 1990. The Married Person Property Amendment Act, the Family Dependent Provisions Act, and the Equal Rights Act. Because of her expertise and leadership on human rights, Justice Bernard in 1982 was elected a member of the United Nations Committee on the Elimination of Discrimination Against Women, CEDAW. This body comprised 23 independent experts that monitors implementation of the Convention on Elimination of All Forms of Discrimination Against Women. From 1982 to 1984, she served as the rapporteur for the committee, and then from 1985 to 1989, she was its chairperson. Justice Bernard also chaired a judicial colloquium in Guyana hosted by the Commonwealth Secretariat in collaboration with CARICOM Secretariat. The purpose of the colloquium was to increase sensitivity and awareness of gender discrimination when encountered by the judiciary of Caribbean states and strengthen the use of international human rights norms and instruments. In later years, she continued to serve, and in 2014, Justice Bernard was a founding member and the first patron of the Caribbean Association of Women Judges, which was formed in 2014. Justice Bernard is the recipient of national awards and a whole host of awards from the University of Guyana, honorary doctorate from the University of the West Indies, etc. Justice Bernard also has published widely, and I have a list of publications here which I will leave it for the record of the court but will not read it out. As a woman of many firsts, Justice Bernard lived her life in such a way that she ensured that she would not be the last. No one can deny that Justice Desiree Patricia Bernard has left a lasting legacy for future generations of lawyers, especially women, to emulate. She came from humble beginnings and through hard work shattered the glass ceilings and paved the way for other women to participate in an arena that was male-dominated. The extraordinary outpouring of condolences from all over the world confirms that Guyana has truly lost one of its most brilliant minds and distinguished daughters. To her daughter Caroline and other relatives and friends, I express the condolences of the law officers of the state, members of the bar, and of course, the government of Guyana on Justice Bernard's passing. Thank you very much, Your Honors.